his lawyer has a couple things on her chest that she'd like to get off, namely the whole grand jury indictment. She's holding a hearing saying it's got to go. We want more time to look through all the stuff that the grand jury had, did, said, all that secret stuff, because we think it maybe didn't go according to law or plan, or there was something hinky in there, which means we want to toss it out. We want that grand jury indictment tossed out. Grand juries are secret, and they really are a prosecutorial process. They're not a defense process. So this is interesting. I like the way she thinks. This is what she says. She says, Kohberger is exercising due diligence to discover the grounds upon which to file a motion to dismiss related to how the grand jury was selected. While the matter of the grand jury record is argued and prepared, she wants more time to go through with a fine-tooth comb. Here's something else that was interesting. She said the grand jury was impaneled at a time when the small community of Moscow, Idaho, had been exposed to 6 months of intense local, national, and international media coverage. Because the state has provided extensive discovery, Mr. Kohberger knows that exculpatory evidence exists. That's interesting. Whether a fair and impartial panel of grand jurors was assembled amidst intense media coverage is a significant question the defense must evaluate. Well, that is interesting. So that's why I get the interesting guest. Mark Geragos, trial attorney, co-host of the podcast Reasonable Doubt with Adam Carolla. Let's start with the money. Mark Geragos, $135,000 for a quadruple murder case. How much more is it going to go up from that? They can't possibly stick to that budget, can they?
It's going to go up quite a bit. And by the way, that's probably why people are fleeing California to go to Idaho, because the cost of living or prosecuting is much cheaper there. I'll tell you, the defense cost alone in a capital case in a place like California or New York is a multiple or exponentially more than that.
Yeah, the prosecutor, Bill Thompson, said it's hard to project exactly what's going to be involved. We know that it's not going to be cheap. That is the understatement of the century. All right, let me ask you about this whole challenge to the grand jury process and maybe the indictment itself. I love it. It's like spaghetti. Just toss it and see what, happens. But how often does this trick work?
Well, it's not so much a trick, I think, and I looked at what she wrote, and I think what she's doing is setting up a situation. When you have a grand jury, in most jurisdictions, and both in federal and state court, you have to give the defense the opportunity to present exculpatory evidence, if you will, once you know the grand jury is happening. And that can be what you just kind of recounted, was whether or not the grand jury was selected impartially. So that's a different challenge. The challenge to exculpatory evidence is, I believe what they're laying the groundwork for the argument is, hey, we know that there's exculpatory evidence. We didn't get a chance to present that. That is our right. Even though it's a secret proceeding, we do have the opportunity, just like in New York, where you and I talked about in the Penny case, where he could or didn't, or we don't even know actually whether he testified in front of the grand jury, because that's his right. When Trump was given the right, he sent one of his lawyers in New York State Court. Here, they could have presented a whole package to the grand jury. I will tell you, going back 20 years, when Michael Jackson, when I was notified that Michael was going to be indicted, I presented and brought, along with Ben Brofman, binders worth of exculpatory information to give to that grand jury so that they would know that before they indicted Michael in that case. So she's laying the groundwork for a motion to dismiss, and what she's asking for, pause this thing. We want a timeout, basically, so we can assemble the information that we would have presented to the grand jury.
I got 30 seconds left, but since you brought up Michael Jackson and you were, his attorney, this complaint about media saturation, that you can't possibly get a fair grand jury, you can't possibly get a fair trial, all this stuff. I look at OJ, acquitted. Casey Anthony, acquitted. Beretta, Robert Blake, acquitted. And of course, your guy, Michael Jackson, in one of his trials, acquitted. So I'm getting a little tired of hearing that you can't get a fair process just when there's lots of media attention. What do you think?
Well, in at least 3 of the cases you just mentioned, you know what the common theme was?
Fame.
Those jurors were sequestered.
Ah, okay.
Casey Anthony sequestered, O.J. Simpson sequestered. When they're not sequestered, that's when you can't protect them from everything that's out there in the ether.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.